Today, we're diving into something called agency law. Now, I know it sounds a bit dry, but trust me, it's this invisible legal force that's humming away in the background of so many parts of our lives, from buying a house to just doing our jobs. It's basically the rule book for when one person acts for another, and you'll see why knowing the basics is so important. So, let me ask you this. Have you ever hired a real estate agent? Maybe called up a lawyer for advice? Or, hey, maybe you have an insurance broker, or even just a regular job where you act on behalf of your boss. Seems pretty normal, right? Just everyday stuff. Well, it turns out that in every single one of those situations, you've walked right into the world of agency law. It's this whole area of the law that kicks in the second one person agrees to act for another. Okay, so let's start at square one. What in the world is an agent? And who are the main people involved in this whole relationship? You know, the definition is actually really straightforward. An agent is just someone who acts on behalf of another person. We call them the principal, and their job is to connect that principal with a third party. So think about it. Your real estate agent, that's the agent, is acting for you, the principal, to make a deal with a buyer, the third party. The agent is basically a legally empowered middleman. But this isn't just some casual handshake deal. A true agency relationship is built on four really solid legal pillars. First, you need consent. Both people have to agree. The agent has to act on behalf of the principal, not themselves. The principal has to have some level of control. And then there's the big one, fiduciary duty. This is huge. It's a legal promise, an obligation for the agent to be completely loyal and always put the principal's interests ahead of their own. It's the secret sauce that makes this all work. All right, so if this relationship is so important, how does it get started? You might think you always need a super formal contract, all signed and sealed. But nope, the law is a bit more flexible than that. There are actually a few different ways this bond can be created. There are really 5 main paths. The one we all think of is by agreement, a contract, either written or just spoken. But it can also be created by estoppel, which is all about appearances, and we'll get to that. Or by ratification, which is kind of like giving a thumbs up to something an agent did without permission, but after the fact. In really rare emergencies, it can be formed by necessity, and sometimes the law just creates it automatically, like when you form a business partnership. Now, this idea of estoppel is pretty fascinating, because it's not about what you agreed to, it's about what you led others to believe. If you act in a way that makes it look like someone is your agent, and another person reasonably believes you and makes a deal based on that belief, the law can literally stop you, or estop you, from later saying, oh wait, they weren't my agent. Your actions can create an agent all by themselves. So this brings up a really critical point. An agent has power, sure, but where does that power, that authority, actually come from? Figuring this out is the key to knowing who's on the hook when a deal gets made. And this is where we see 2 totally different sources of power. First, there's actual authority. This is the power that the principal and agent agree on behind closed doors. It could be express, like you can spend up to $10,000, or just implied, the stuff you need to do to get the job done. But then there's apparent authority. This comes from what the principal communicates to the outside world. If a CEO tells a supplier, yeah, just deal with Sarah, she handles all our purchasing, then Sarah has apparent authority to make those deals, no matter what her internal job title is. And check out this table. It pulls it all together. Just look at that last column. It doesn't matter if the authority was express, implied, apparent, or even approved after the fact by ratification. The result is the same every time. The principal is bound. That's the bottom line. Once that authority exists in whatever form, the principal is on the hook for the deal. Which, of course, leads us to the million-dollar question, what happens when it all goes wrong? You know, the agent makes a terrible deal, or even worse, does something they shouldn't have. Who has to pay the price? For contracts, this table breaks it down perfectly. If the agent has authority, and everyone knows who the principal is, we call that a disclosed principal, then it's simple. The principal is liable, and the agent just walks away. But if the agent acts with no authority, then they're the one who's personally liable. And look at that last row. If the principal is a secret, if they're undisclosed, the third party might be able to sue both of them. Okay, but what about wrongful acts, what lawyers call torts, things like negligence or fraud? Well, here the rule is pretty simple. The agent who did the wrongful act is always on the hook, personally. You can't just say, my boss made me do it. But, and this is a big but, the principal might also be liable. This is something called vicarious liability, and it often applies when an employee does something wrong while on the job. Whew. Okay, we've covered a ton of ground here, so let's just boil it all down and focus on the absolute key takeaways, the things you really need to remember from all this. First and foremost, if you remember one thing, remember the massive difference between a disclosed and an undisclosed principal. If you're ever acting as an agent, you want everyone to know who you're working for, because when the principal is disclosed, you're usually off the hook for the contract. But if the other side thinks you're acting for yourself, you could end up being personally liable for the whole deal. And finally, you can see these agency roles playing out all over the business world. Just look at the difference between a partner in a firm and a director of a company. A partner is an agent for the other partners, and they have unlimited personal liability. Yikes. But a company director, they're an agent for the company itself, which is its own legal person. That creates a kind of corporate shield that usually protects them from personal liability. It's the same fundamental idea of agency, just with very, very different results. So I'll leave you with this question to think about. Who in your life right now has the authority to act for you? A coworker? A business partner? Your financial advisor? And now that you know the rules of the game, what happens if they do?